Good morning. My name's Sean McEwen, and I'm the publisher of Inside Aging. And I'd like to welcome you here today to today's webinar, What Migration Can Do for Aged Care's Workforce Challenges. And we're joined by Melanie McFarlane, who's the CEO and Principal Consultant of Migration. Welcome, Melanie.
Thank you, Sean. Great to be here.
Today's session came about really because of a story Melanie wrote for us. She wrote a story about a month and a half ago about all the other solutions that are kind of out there to help aged care with its workforce challenges. And the story was very well received. It was probably our highest read story for the month of July, August. So obviously, as a publisher, you want to pick up on these things, especially if there's sentiment around it. And with the Jobs Summit, obviously there's been a lot of sentiment to do with workforce and just what some of the solutions are. So today's session is a follow-up, and obviously with Melanie here with us today in this live session, you can ask questions. So you'll notice at the bottom of your screen there's a box where you can type your questions in. So type them in, and you can type them in throughout the session. So as Melanie's presenting, feel free to type those questions in, and we'll go through them at the end of the session and answer them. And we've already had a few questions already where people have asked those at the time of registration. So without further delay, I'll pass over to Melanie to start the presentation.
Thanks, Sean. All right. Go. Share. All right. So great to be here. Thanks very much, Sean. This is a sector actually in aged care that we've been working in for some time now as a company. And what I'm going to talk about today is the aged care sector in the context of immigration options, obviously. Pathways for aged care students, for example, because that's one area that can be picked up on those international students actually who are here already. And then I'll talk a little bit about the different types of visa subclasses that can be used in terms of immigration pathways. I'll talk about the labour agreement, because that's a pretty important area of immigration for the aged care sector at this point in time. And then looking at recruitment, both onshore here in Australia and offshore outside of Australia, and the advocacy that's required by the industry. I'm a passionate advocate myself, and I'm always wanting to help the industries that we work in and work with for the purpose of immigration to advocate to government in terms of immigration and where they can be helped with immigration pathways and so on that perhaps don't exist at the moment, and government could facilitate those. And I'll talk just a little bit about what we do ourselves at Migration and Recruitment. And then, as Sean mentioned, there'll be time for questions. So that's basically an overview of what I'm going to go through today. So just a little bit, very brief overview of what we do. I'm a migrant myself. I came to Australia over 20 years ago now, and I'm really passionate about helping clients, both employers and individuals alike. We have particular expertise in visas for childcare and the aged care and hospitality industries, but a lot in the care industries, and more than 15 years now as a company. And our mantra is happy people, happy world. It may sound like a naive mantra, but it's genuinely what we want to do. So now I know I'm preaching to the converted in terms of what's going on in the aged care sector at the moment. Of course, we're going through this significant generational shift where baby boomers and millennials represent 5.4 million people. And so, you can see where we are. We all know that Australia is facing this demographic cliff. And in fact, some of the immigration policies that were introduced earlier this century actually were as a result of the knowledge of that demographic cliff coming along. But the result is, especially with COVID, border closure and so on, is that Australia needs to find an extra 35,000 aged care workers per year. So it's according to a recent Committee for Economic Development of Australia report. So it's pretty significant. And I know those of you, I'm sure those of you who are watching are very well aware of this. Hence, there are a few questions already that I've seen that I'm prepared to answer. I've already prepared to answer around this area. So it certainly is going to be, immigration is most definitely a key driving factor in maintaining the aged care workforce referred to in the Royal Commission report, I think page 124, if I'm not mistaken. And of course, the recent Jobs Skills Summit that Sean referred to address this as well. So, you know, pre-pandemic data indicates that approximately 30% of the workforce were immigrants. And since the borders have reopened earlier this year, the number of migrants still low. That's still something that remains a concern. Many personal care workers are not eligible for a skilled migration visa. There's not enough occupations that they can go into and get skilled migration or apply for permanent residence under their own auspices. So there are a lot more pathways, a lot more clear pathways to permanent residence are required in the aged care sector. And as I mentioned in the overview, whilst the government has announced that there are 195,000 PR places in October's budget, which is an increase from the previous 160,000 slashed to back in 2017, 2018. It's really important that government looks at more clear pathways. But I will talk about solutions. I'm not just about talking about where the holes are. I'm also I find it very important to talk about what the solutions are right now, actually, because there are some solutions, but then there are more things to advocate. So on that note, you'll see at the bottom of this lovely little rainbow that I have put a skilled migration pathway. It is available to some who are working, who have community worker studies and who are able to obtain a skills assessment. The New South Wales, for example, I'm just talking New South Wales, but there are many obviously other states in Australia. The New South Wales occupation list has that occupation on it. And so there is a means for some applicants who have studied here in Sydney, in that area, to apply for permanent residence, but it's very particular and it's not that clear and it's not that easy. So when we don't have clear pathways, Australia being far away from the rest of the world, people are not likely to be so attracted to come here and work. And as we know, in developing countries around the world, Germany is another one actually. In Europe, you know, there is also a huge issue with regards to the aged care sector and the lack of available skilled people to work in that area. But here in the in this rainbow diagram, I have noted studies. This is really for applicants who are onshore, but it can be for those who are outside of Australia as well. But those who are studying here, or those who can come here and study, because at the moment international students may work full time. That is until June, the end of June 2023, so June next year. International students may work full time, which is an advantage, of course, for the sector, whilst they are actually studying something that's relevant as well. I do know that the Royal Commission has declared that at some point in the not too distant future that anyone working in the sector will need to have the equivalent of that Certificate 3 in aged care support. But those who have studied in that area can then actually go on to a training visa. And I'll go into detail about that in a moment. That visa is a visa that is sponsored by an employer. After that visa, they can obtain sufficient work experience to then go into to labour agreement stream. And then, if that all works out, they've had 3 years on that visa, then they can then undertake and be sponsored. This is individual applicant for the 186 labour agreement stream, and that is a permanent residence application. And so the applicant would actually receive permanent residence. And we do have candidates who are on that pathway at the moment, and we have employer clients who have undertaken this labour agreement and have candidates who are some on the training visa, some on the 482, and I'll talk about what those visas are now. So in terms of the training visa, that's the subclass 407. This is a great visa whose purpose is actually to enhance relations between Australia and the rest of the world, actually, to train and upskill candidates with the view to they're taking that skill set back to their country. The reality is there's no reason why they can't then use that skill set to obtain further work experience and indeed stay on longer in Australia and continue to work in that occupation. So they need to show that they're being upskilled to this occupation of manager. They need to have a skills audit and training plan. That's something that when we undertake this visa for our clients, we actually organise. We have a trainer who's very skilled in preparing those types of training plans. They can apply from a 485 graduate visa. That's a visa that allows an international student to work full time. They need to show 12 out of the last 24 months of relevant work experience or relevant studies. So if they've studied, say, the diploma or the certificate 3 in aged care, then that would count as relevant studies for 12 months. And they can't be too overqualified for the position. So the Department of Home Affairs can look at previous applications if they want to ensure that there's the same data always being used. And as I said, work experience on this 407 visa can then be used for the next visa of sponsorship, which are still temporary visas. Because for anybody working in this sector at this stage, it does take several years to obtain permanent residence following this pathway that I am mentioning, which is another reason I believe that there does need to be further advocacy to government around this. And I'll come to that. And so a labour agreement stream, I know a lot, maybe there may be quite a few on this call who are interested in seeing what that and understanding what a labour agreement is. So a labour agreement is a very specific type of agreement. It's a type of sponsorship agreement that is negotiated with Home Affairs. Pre-COVID, actually, aged care was about to receive an industry labour agreement status, which meant that it was kind of pre-approved by government. But that never happened. COVID took place, and then the Royal Commission and so on. And so up to this date, an industry labour agreement hasn't been actually approved. But what we did find a few months ago when we launched a labour agreement was that in the aged care sector, it went through very, very quickly. And I think that's some indication of the fact that there was going to be an approval for an industry labour agreement in aged care. So it's a very specific agreement where some occupations on that agreement are just not able to be sponsored for the normal 482, which is the temporary skill shortage visa. The temporary visa will last between 2 to 4 years. But under a labour agreement stream, this is for a maximum of 4 years. You need to be nominated to work in a specified occupation under the terms of a labour agreement. So, for example, in this industry, we could have support worker, and we have had support approved in the labour agreements we've put forward. You need to have, in many cases, 2 years of relevant work experience in that nominated occupation. In some cases, a relevant skills assessment, but not always. You must work only with the individual. You must work only for the sponsor. So as an employer, that's the advantage, obviously, that if you're sponsoring, because it can be quite expensive to do so, that the person working for you and sponsored by you will only be able to organisation. And you need to meet minimum, the individual that is, needs to meet minimum standards of English proficiency. So that's the 482 labour agreement stream. And then the next part of it, which then goes to permanent residence, and that has to be requested in the actual application. Sometimes immigration, in their wisdom, will say, well, we're not going to give the permanent stream now, you'll have to vary the agreement later. So that's exactly what happens. A labour agreement can be approved with only temporary positions in place, and then you have to apply to vary it and ask for the permanent places. But other times you can ask for fell swoop for the aged care sector, because it's been a critical sector throughout COVID and it's still deemed to be a critical sector for the country, for the economy. Then to take advantage of that. And the fact that Labor has really emphasised the fact that they want permanent residence pathways, and of course, they just increase the number of visas accordingly. So the 186 subclass is permanent residence, again, sponsorship under the Labor agreement stream, and it's within 3 years of that applicant holding that 482 visa, again nominated by the employer. The applicant normally needs to be under the age of 45 years old when they apply, unless an age concession is granted. Again, that has to be applied for under the Labor agreement, and they need to hold either a 457 or a 482, the TSS 482 visa. And in some cases, a relevant skill assessment, but not in the area of aged care. And again, English language proficiency. They need to have a slightly higher level of English in order to get the permanent residence than they did the applicant did temporary residence visa. So basic requirements. If there are any employers, I'm sure there are on this call, on this webinar, here we are. I mean, there's a few more. We'd go into more detail, obviously, but some basic requirements are that the business needs to demonstrate that it's been operating for at least 12 months and is financially able to support its workers. So that's, that's through showing financials, profit and loss, business tax returns. If there's any loss in the business, then that needs to be accounted for by the company accountant. There's usually reasons for that, but normally finance healthy, and so that's all good. The ability to demonstrate a genuine labour market need, which means basically labour market testing, so advertising for that position already with the appropriate salary and so on, and demonstrating that the agreement is to supplement already existing fees and not undermine the Australian workforce. So that's obviously, that's key as well. In any sponsorship application, are indicating the number of Australians already working in the business. And if there aren't very many, well, the fact is we do know that immigration is key for the aged care sector. And so that in itself can be readily explained with statistics and so on. And the other important point is that it's important to consult the relevant industry stakeholders, whether that's unions, agencies, industry associations, and there's quite a few industry associations that we have worked with ourselves to obtain letters of support for our clients in aged care, and those have been sufficient to be able to get the labour agreement approved. So those are the basics for having a labour agreement. So I'll just talk a little bit about the pros and cons of onshore and offshore recruitment. So pros, obviously, you're getting access to specialists and experienced employees. And onshore, you're getting a lot who are international students and have already studied in this area and have already been able to work in the area whilst they study. So you may possibly have already been able to train them up actually in the area. Of course, scale your business quickly, so you're obviously going to be able to have a flexible workforce. I know, having spoken to people in the sector, that it's very tricky scheduling rosters and so on, regards to workforce issues. And as I mentioned already, actually, is the other point, allows onshore employees to upskill and move up into the next level of sponsorship. And of course, those who are already studying here in Australia are very motivated to keep working and to be sponsored along these pathways. And to bring those from offshore, from overseas, it's a way, of course, also to supplement the workforce as long as they have the appropriate qualifications and so on. So cons, I mean, fairly obvious, I guess. Local entity registration, you've got to go through the sponsorship process, but that's something that we assist with. There is the expense as well of it. Of course, it does need to be paid for. And I'll come to an advocacy point around that actually shortly. You're obviously managing people who are coming from overseas. I think in that regard, it's important to align their expectations to what the position's going to be, to what they can expect. now and in the future. So that's where it's quite useful if they come in on a temporary employer-sponsored visa to show them that, you know, if they do well, obviously in those 3 years, for example, then they can obtain their permanent residence afterwards. Now, language concerns generally tend to be dealt with by the fact that they must have a certain adequate level of English in order to be able to apply for the visa. And no doubt from an employer's point of view as well, of course, it's to communicate very well to this particular cohort of client in the education sector. And then acceptance from local employees. I would say, with the knowledge that I have at these days, it's pretty widely accepted that there's going to be many people from overseas in this sector. But there we go. I just learned a little bit, because then it also I can talk then more to what exactly the requirements are to ship. Now, I mentioned I was going to talk about advocacy. So back in December 2019, there was what's called a traffic light bulletin, which is it's essentially a document that highlights occupations that are going to be added to the future. And this traffic light bulletin in December 2019 was very exciting for the care industry, because it actually highlighted that there were 3 carer, that should say carer, not career, pardon the typo, carer occupations to be added to the 482 list, so the temporary skill shortage list. And that would have made things a little easier, because those occupations, companies would then not have had to go through the whole labour agreement process. That said, I mean, we're, as a company ourselves, MM Migration Recruitment, we're pretty au fait with what the requirements are for the aged care industry in terms of labour agreements. But nonetheless, it's quite nice to eliminate that additional hurdle if you can. And also, if those occupations could go to permanent residence, then it gives motivation and incentive as well to those candidates who are applying and working for the 3 years. They know they can apply for permanent residence. So my suggestion is that to government is that these occupations must be added as soon as possible. I'm not the only one in the industry saying this. These 2 occupation lists, at the moment there's 2 occupation lists for 482. Back in 2017, the government then decided in their wisdom that they would separate the lists, and one would be occupations that were just temporary, that would never go to permanent residence. The other would be some that would go to permanent residence. Now, was that a good move or not? Well, many would argue that actually it made Australia less favourable as a destination for migrants to come to. And of course, as a country that's very far away, we need to attract global talent. So the suggestion now is to amalgamate those lists and for all occupations to go to permanent residence. The government in the previous government did allow some compromise for those workers who were working here during the pandemic, that they would, regardless of what occupation list they were on for the 482, some of them would be able to still go to permanent residence. But there's still a lot of grey area around that, and the current government has not clarified that. So that needs to be clarified also, actually. Labour market testing, scrap that. I mean, it's just crazy. Such a low unemployment, 3.4% unemployment rate, skills shortage, widely publicised. Why on earth would we need to advertise in advance when it's very clear and apparent? And it's even the Commission talked about the issues with resourcing and workforce, resourcing in the workforce. So, and the other thing, when I talked about cost, there is a big cost in terms of sponsorship, not for the training visa, but for the 482 visa, which is the Skilling Australians Fund. And I think Labor is now, they talked about in the Job Skills Summit, that they were going to be putting a lot of money into training for young Australians. And this would come from the Skilling Australians Fund that is essentially like a sponsorship tax. Each company has to pay it, and it can be anything from 4,800 up to 7,200 a pop for for each applicant. So it is costly, and I believe that there should be advocacy in aged care to reduce those training contribution fees for critical sectors such as aged care. The other issue is that there's some of you may be aware there are some reviews that are going to be taking place for immigration in the future, and one of those is looking at the minimum salary for sponsorship. So it's really important that when that comes about, that minimum salary is in line with the wage salaries being paid in the aged care sector, which I understand there's been a review as well within the sector with regards to the award wage, but it's important to bear in mind that minimum salary at the moment, which is $53,900, that will it is going to increase. So it's important to be part of that conversation, I would say. And in the job summit that came up, and there were some industries advocating for a tiered or some type of minimum salary that is tiered according to which industry, and that's something that I've argued for a long time, and some of my colleagues too. So yes, I really truly believe, and actually, if there's going to be a labour agreement for aged care, the aged care also needs that industry aged care agreement, which it never obtained in the end, pre and then now post-COVID. So that's something else that could be looked at as well by government. So yes, so just a little bit. That's basically all I wanted to say, because I know I really should allow time for questions and what have you. I don't want to hold the time doing this presentation, but I just felt those points were important. A little bit about us. We do the recruitment side as well, and we can help access experienced and perfectly matched candidates. We've done this actually successfully already within the aged care sector, amongst others that we work within as well. We do have a lot of international students. We have an education consultancy with offices actually in Latin America. And we're also working with a large recruitment portal at the moment, bringing candidates from overseas on work and holiday visas from the UK and Ireland specifically, as well as I said, the international students that we're bringing from Latin America too. So it's time to get on to those questions. I might hand over to you, Sean.
Thanks very much. Thanks, Melanie. I really appreciate you taking the time to explain all of that to us. It's certainly timely, as I said before. There's been a few questions that have been asked when people registered, but just a reminder to everybody that you can still type your questions in at the bottom of the screen, and we'll pick those up as soon as I read the questions that have already been asked in advance. So let me just do that now. So migrant refugees, students and temporary visa holders have been helping our industry over the years. We're working mainly with language-specific groups and providing care in 18 to 20 languages for the last 20 years, and would like to know more about visa categories and what types of visas will be decided on. Thank you. And this was from a community care provider that asked this question.
Yes, right. Well, yes, I mean, that's absolutely right. You know, and I was talking about, actually refugees too, of course, and absolutely international students, because we have so many who are our clients and our candidates for our aged care centre clients. So yes, they've certainly been working in the industry for such a long time. With regards to the different visa categories and what type of visas will be decided on, I think I may in the presentation have answered that with regards to the types of visa categories that can be used in order to obtain permanent residence ultimately for those who have been assisting the industry. I think that training visa is a really important one, actually, because at the moment, what I didn't mention was that because there are no occupations on a specific list, without going into too much detail and confusing everybody, the international students studying in this area can't actually apply for the graduate visa, except for this caveat year between July 22 to June 23, but I won't dwell on that too much because it's such a short period of time. But otherwise, they cannot apply for that graduate visa. And so they, unless they go on study a bachelor or master degree, which many don't want to do if they're working in the sector and they don't need it, particularly, and it's expensive too. The training visa is quite paramount, actually. But as I said, it does require employer sponsorship. And then the other types of visas, 482 and the 186, also require employer sponsorship. So what I would say as well, and I possibly should have mentioned this more in that advocacy piece, that the presentation, but that's why questions are always good, because they can add to that presentation. But I think there need to be more occupations on the actual skilled migration occupation list, so that individual applicants who are working within the sector can also obtain a skills assessment, have the relevant English skills, obtain the points, and be able to apply themselves. So that's another visa. Those visa categories would be the 190 and the 491. The 491 is for regional areas. So yeah, those are the ones that I would mention as well.
Yeah, I mean, this is a question from myself, Melanie. You just mentioned 491 for regional areas. And I do know for a fact there's a few regional providers on the session today.
Right.
Where they are experiencing significant issues, more so than their city counterparts.
Right.
With respect to finding and retaining workers.
Yes.
Tell us a bit more about that 491 visa, if you can.
Of course. So the 491 is a visa which is for the individual themselves, where they can actually utilize the points test. They have to be, the points test encompasses their age, points for their age, their English level, and then their education, their years of work experience, and then the skills assessment that they must have a skills assessment. So, but the fact is they have to have an occupation on the list in the first place. That is then each state, whether it's New South Wales, ACT, WA, or what have you, has its own occupation list specifically for immigration. Western Australia has been fairly aggressive, I would say, in the last few months, actually, interestingly, putting on a lot more occupations to attract migrants from overseas and onshore too. Some of our clients have gone over from the east to the west, actually, for that reason. But so each state has its individual occupation list, which then must also fit into the general 491 list. And that visa is a temporary visa, but it does give access to Medicare. It's for 5 years, and after 3 years, the individual can apply for permanent residence. But the key is the occupation and the skills assessment, and the appropriate occupation being on that 491 list in the first instance. Just another subclass for the regional areas is the 494, which is specifically a type of employer sponsorship for regional areas. And that does have a little bit more leeway with regards to its occupations. But I think there needs to be, it's all very well government, and I understand they have to be big picture, but they really have to drill down now and be more industry specific, especially in critical sectors such as aged care. They really need to look at where all these different holes are. And it comes down to the specific occupations. So that, yeah, I'll just keep going on about that because it's so crucial actually now.
Well, there's another question here. Again, this was asked in advance, and this is interesting because this is from somebody based in Fiji who wants to come to Australia. So we're going the other way now.
Yes.
The question is, I'd like to know more about the skilled migration process, as I work as an auditor in Fiji for 16 years. So obviously quite experienced and qualified. I mean, how would this person go about finding her way to Australia?
Yeah, I mean, it is interesting, actually. Obviously, I'm slightly blind, not knowing too much about the background, but the reality is it's about what I just mentioned with regards to the actual skilled migration process when it's not based on employer sponsorship. There are very broadly, there are those two ways of applying permanent residence, either through skilled migration points test or through employer sponsorship and different types of employer sponsorship, which ultimately lead to permanent residence. And skilled migration, again, is about that points test. So it's based on age, English level, and so on. And age is an issue because if you've been working for 16 years, that individual probably doesn't have. I don't know what age that they are, but age is an issue in the sense that for the points test, the older you are, the more points you lose. But with the logical conclusion that you would be able to obtain more points for your work experience as you are older, that will make up for the points you lose for your age. And there is encouragement to go to those regional areas. So that's where the 491 visa, I'll come back to that again, because there are more points given for those who apply for the 491 visa, as opposed to the 190, which is where you could go to the cities, Sydney, etc. So I guess I have to address that question very, very broadly in that sense. But I mean, the occupation of auditor has been on many skilled occupation lists. So there are possibilities there. And the other option, because I've worked with international students also for so many years, having an education consultancy too, is sometimes we bring people over who want to study in a completely different area. So they may have worked as an auditor, but they want to go more into aged care, for example. So we bring people in to study in that area, to see if they work in that area, and then look at pathways for them post-studies. Therein lies another issue, which is the genuine temporary entry requirement of the student visa, whether or not the Department of Home Affairs will let them in because they're having a complete change of career and so on. But that's where, in fact, in our industry, in my industry, we've been advocating to remove that requirement because it does lead to subjective decisions. But regardless, we have to work with that and see if we can help people come in to study and then to move on. Or if we know more about the candidate and we have the employers that we're working with, we can organise the recruitment and immigration process. So there's quite a lot of answers there to that one simple question.
Thanks, Melanie. Thanks for a very thorough response. We've got a live question here, which I'll go to mainly because it mirrors another question on our list that was asked.
Yes.
So you might be able to see it there, but I'll read it out so that our audience can hear this.
Yes.
This is from John. John's an aged care provider. And John's question is, how can one counter the risk that sponsored staff will leave your employee and find alternative employer sponsor nominator, particularly if one has advanced funds to cover the costs of flights, education, registration, and visa? I am familiar with the preclusions of recovering costs, as in he's mentioned R260S, which I presume is a currency, but can professional development contracts ensure cost recovery plus a margin for risk and interest? Will this issue worsen if the government moves towards permanent residency rather than work visas, the old 457 he refers to, as once they have PR, they can more easily leave your employee and find another employer? There's a lot in that, but
there is. But I know that question because I've been asked it many times in the past, and thank you very much, John, for that question, because I think a lot of people will be thinking along those lines. Yes, of course, especially that can be the disadvantage if you're bringing somebody in from overseas. You're paying all of those costs, and I know there was another question, wasn't there, Sean, which alluded to the fact that can you put into your employment contract that you, should that person may not leave your employee for a certain period of time because they are sponsored by you. So I just thought I would bring that in at the same time. This is a very tricky area because one of the issues, when you sponsor, there are a certain amount of sponsorship obligations. And one of those obligations is that the sponsor may not recover the costs of sponsorship from the visa applicant. So the visa applicant can actually pay their part of the costs. In fact, some employers may choose to pay all of them, but the visa applicant may pay their part of the costs, and even the fees of the migration agent to apply for the visa, whereas the sponsoring employer needs to pay the sponsorship and the nomination costs. So yes, it can be risky if that person comes over and they can be poached potentially, or may decide to leave after a certain period of time. This is tricky because employment law is very much entrenched in immigration law. The Fair Work Act, for example, finds itself mentioned several times within the temporary skills shortage 482 visa legislation. And so any employment contract that is provided to the employee must be in keeping with usual employment law provisions. It is and you know, can you have two employment contracts, one specifically for immigration law purposes? That doesn't really cover it either. So you have to be very careful in that regard. Nonetheless, if somebody does leave your employ once they've received sponsorship, they have to be sponsored again. So another employer has to go through all of that sponsorship. They cannot work for another employer sponsor until they've received a new nomination approval. And if they are on a pathway to permanent residence, their 3 years will start all over again. If they come in under a labour agreement, that can be very tricky because labour agreements actually can take around, well, historically around 9 months. I mean, we did actually manage to get a labour agreement approved within 1 week just recently for our aged care employer, for one of our aged care employers. But often labour agreements can take quite a long time, and so therefore another employer may take time before they can take somebody on board. I realise I'm kind of going around in circles a little bit because this is a very tricky question to answer. And even though I had time to look at, prepare for the one with regards to the employment contract, it's very difficult actually to answer it. I think the communication obviously is key with that, with the applicant around what the consequences are if they leave that sponsored employer and what they would have to go through in order to find another sponsoring employer, and that they wouldn't be able to work until a new nomination were approved and so on, so they could be out of work, etc. But can you put, because the obligation, the only way that could be one, because the visa costs can be paid for by the visa applicant, that could be one way of putting within the employment contract that if the employer pays for all of the costs in advance, that the visa applicant may forfeit those the costs payable for the visa. That could be the best way around it. And you've said, John, will this issue worsen if the government moves more towards permanent residence rather than work visas? Yeah, it's interesting, isn't it? I mean, that's the desire that the government has expressed, and they don't want this guest worker economy and what have you. I suspect, like most governments, they're going to have to reach some compromise, because the reality is, you know, you can argue, well, what's wrong with having a certain proportion of the workforce as guest workers? And can you give them all permanent residence in one go? 195,000 is still 195,000 after all. And so at some point, I think many are still going to need to be on temporary visas. And I think with all the consultation and reviews and what have you, I don't quite see how they can provide permanent resident pathways for everybody immediately to cover all of the needs of the sector. And so I would say that there's still room for compromise, and it's going to take a considerable period of time anyway to change a lot of the legislation in place at the moment, which means a lot of temporary workers still.
Okay, thanks, Melanie. Another one of our questions that were asked in advance, and this goes back to what you've been saying about the lists. And the question is, why are we still applying labour testing for registered nurses when there is a national shortage? And the second part to this question is, can we remove roadblocks and reduce processing time to 8 weeks?
I'd love that. That would be just fantastic. I've certainly been advocating for that throughout this year, whenever I can, in the media and what have you. I agree completely. And there was talk in the Job Skills Summit from a lot of the industry bodies about scrapping labour market testing. So I'm very hopeful they will do that, because the unions seem to recognise and understand that it's pretty useless as well, actually. And so I hope it's not just for registered nurses, but yes, again, if they're going to, why can't they just scrap it for occupations in the critical sector? And you know, in the good old days, at one point, the 482 visa, the temporary skill shortage visa, which was the 457 at that time, was actually processed within 48 hours. Now that shows that it is possible. So 8 weeks, yes, it definitely can happen. There is just a huge visa backlog because of what happened some years ago. The government, when they reduced the number for permanent residents, what they did really was they just stalled a lot of people in their visa process, and they just created a massive backlog of bridging visas. So that backlog now is slowly but surely going to be reduced, and there's more money being put into immigration by this current government. And so I'm very hopeful and optimistic that, because there's been so much importance placed on immigration recently, that the processing time is slowly but surely going to be reduced, and priorities are really going to be done properly. For example, these occupations.
Yeah, thank you. I think that's all the questions for today. I'm mindful of our time. We're getting sort of close to 50 minutes, so it's been a good session, yes. Melanie. Thank you very much. We've had somebody ask a question about the recording from today. So what we'll do, we'll upload this recording to the Inside Aging website. And we'll send a link out to everybody that's on this session to view that, and it'll be bookmarked, so you can go back and sort of go to the areas in Melanie's presentation that are most interesting to you, and that'll be a permanent reference for the industry. And we'll include Melanie's details. So if you have any questions, feel free to reach out to Melanie. I think you'd be okay to take emails and a live.
Of course, absolutely. I'd be delighted.
Fantastic. Well, thanks again. And as I said, everybody look out probably later today for the story update. And yeah, thank you.
Thank you. Thanks a lot, Sean. Thanks, everybody.